Good morning. We'll start today's class in continuation with whatever we learned in the yesterday's class. So, what all things did we cover till today in Constitution of India? We started with how British India how India was when British left us, which means India was the British India, consisting of both India and Pakistan. We talked about Afghanistan being our neighbor, so you had the Durand Line. Then we talked about Radcliffe Line in Punjab as well as in Bengal. Then we talked about the instrument of accession, discussed about three princely states in particular, which were Junagadh, Hyderabad, and Jammu and Kashmir. In the second class, what we discussed was the historical background by which we reached our Constitution of India. So we started with the Charter in 1600. Then we discussed about Battle of Plassey. Slowly we went on to our Constitution. All those things in the Parliament. And there was Viceroy Wavell coming in. And in between, we discussed even about the Sepoy Mutiny or our first freedom struggle, and then how when Indian National Congress was formed, all those things. Then we came on to the Constituent Assembly part, before which there was this draft presentation of Pandit Jawaharlal Nehru. Constituent Assembly was formed, then all those things, and finally, which ended up in Constituent Assembly adopting the draft which was made, or which was the chairman of the drafting committee being Ambedkar, Dr. Ambedkar, and then we became a republic in 1950, January 26th. Then in yesterday's class, we entered into the actual constitution, where we discussed about the preamble. In the preamble, I said it's just an introductory statement, and it is just like a manual for any appliance. Everything which is being discussed in the or you know what to expect for in the Constitution by reading the preamble. Preamble was, and I also said the preamble was actually, at first it was the objective resolution which was presented by Pandit Jawaharlal Nehru in 13th December 1946, and that was adopted as the preamble. It was modified only once by the 42nd Amendment Act, and I said by which they added three words. One was socialist, second is secular, and third was integrity. Unity was there. Now it became unity and integrity. And then I said it starts by the sentence, "We the people of India." This is it on behalf of all the people of India. And its nature is described by 5 words. Which were they? We discussed that in detail. One was sovereign. The other was socialist. Sovereign was there. Socialist was there. Then there was the secular. Then democracy. We discussed all those things in detail. Then the republic, and that is where we stand as of now. Those 5 words are prove the nature of the Constitution. What were the objective? 4 words were there. What were they? The objectives were described by the words called justice, equality, liberty, and fraternity. So, and that is where we stand as of today. Okay. So now we are going on to a little more about preamble. Today, we'll discuss a little more about preamble. Okay. Now the question is preamble. Okay. I hope all of you can see my presentation. Aditya Krishna, always I call him. Abhijit, can you see my presentation? Is the whiteboard clear to you? Abhijit is not there. Who can I call? Esther Hanna. Esther.
Yes, ma'am.
You can see, no? Okay.
Yes.
Oh, so as far as the preamble is concerned, 2 questions have to be asked. 2 questions were asked. Okay. One was, is the preamble amendable? or can you amend the preamble? Second question is it a part of the constitution? Part of the constitution. Constitution comes later. Preamble is just the introductory statement. So the two questions which were asked in the past and which had led to a very important cases, court cases. Two questions were: one is can you amend the preamble? Second question is preamble a part of the constitution? Now, very importantly, remember this. There is an article called Article 368. Remember this number. There is an Article 368 which discusses about the power of the Parliament to amend the Constitution. Powers of the Parliament. Why do I always say Parliament? Because Parliament to amend the Constitution. Now, why do I always say Parliament when I come to articles and constitution? Because Parliament consists of the legislature. Parliament is the legislature, isn't it? Which is the law-making body. So anything and everything in the constitution, Parliament is abiding by. Parliament is the safekeeper of the constitution. So Article 368, you have to remember this article by heart, this number by heart. Article 368. Okay, Article 368 discusses about the powers of the Parliament to amend the Constitution. Now, if you want to amend the Constitution, yes, they have given the powers. But the question is preamble a part of the Constitution? That is the question. Okay. So, Article 368 gives power to the Parliament to amend the Constitution. The question which arose was, if so, is preamble a part of the Constitution? So, there was a case called Ray Berubari. Remember some of the cases so that when you answer a question, you can make it more authentic answer. Okay, Ray Berubari Union case and some other cases also. Ray Berubari case. In this case, the Supreme Court said that Article 368, through Article 368, Parliament can make amendment in any part of the Constitution. That is correct. But preamble, the judgment was, preamble is not a part of the Constitution. That was the judgment. In Ray Berubari case, the judgment of the court, Supreme Court, was that preamble is not a part of the Constitution and hence cannot be amended. Amended means cannot be changed by using Article 368. Hope this is clear. So, in Ray Berubari case, whatever be the case it may be, there was a situation where the question was asked whether preamble can be amended. So the opposite party said that as per Article 368, the Parliament has the power to amend the preamble as well. So the court said, no, Article 368 has the power or gives power to the Parliament to amend the Constitution alone. Preamble is not a part of the Constitution. So it cannot be amended by the power of Article 368. Now what happened? One of the most important cases in the history of India or the Supreme Court is, second case is Keshavananda Bharati versus State of Kerala. This is a very important case. Remember about this case as well, which is, this, without knowing this case, no law student will be there. There will be no law student who doesn't know about this, because this is very important. Now, that case of 1973. I'm citing this not because we are all living in Kerala, but I'm citing this because this is one of the most important cases which has a long-standing impact on all the other cases that happened later and is just happening now also. This Sri Keshavananda Bharati died very recently. That was there in the newspapers as well. Now let's see what happened in the previous case, which is the Berubari case, Ray Berubari case. Supreme Court, what did Supreme Court say? It said that since preamble is not a part of the Constitution, it cannot be amended by using Article 368. But Supreme Court had a lapse there. When they give the verdict for this case, it did not take into account the fact that preamble was also adopted and enacted in the same manner as the Constitution. That is, the preamble was along with the Constitution adopted by the Constituent Assembly in 1949, and it was enacted in January 26, 1950 in the same manner as it was done for the Constitution. Hence, preamble is a part, the verdict or the judgment is that preamble is also, in this case is that preamble, unlike in the previous case, where it was the Ray Berubari case, where it said that preamble is not a part of the case, after a lot of discussions, a lot of court arguments, the judgment came that preamble is also a part of the Constitution. And what is the importance of that? Hence can be amended by using Article 368. But there was a certain restriction that the Supreme Court put. What was that? It should not, any amendment if made, it should not affect the basic structure of the Constitution, or the basic doctrines for which the Constitution stands. So because of this case, 42nd Amendment came in. Do you remember we discussed about that? 42nd Amendment, by which they added 3 words were added: secular, those things, socialist, secular, integrity, all those things were added by 42nd Amendment. How? Because of this judgment. It could be added. Why? Because it doesn't affect the basic structure of this. It is for the welfare of the people, and it doesn't affect the basic structure. It doesn't affect the fundamental rights. It doesn't affect the fundamental or the fundamental duties. It is just giving a better version to the preamble. So that is Keshavananda Bharati versus State of Kerala, about which I would like to go a little more deep into it, because it may not be required for your exam, but it will come in handy for many of you while you are writing your exam, and also it's a very interesting topic. So let me devote a certain 5 or 10 minutes for describing that. What is Keshavananda Bharati case? Because this is one of the most important cases about which you should always remember. Now, Keshavananda Bharati versus State of Kerala case. Now, it is also known as Basic Doctrine case. And it is also known as a case which saved the democracy of India. Now, very interesting facts are there. One is, this particular case had the longest proceedings in the court. Longest proceedings means what? longest time of argument in the court. How many days? 168 days or 68 days or something. Longest 68 days it was argued. More than 100 previous cases were cited. What do you mean by cited? Cited means, so in those and in that and this case, this was said. In the case between this and this, so 100 cases were cited so as to win the argument, and it was compared, and comparison was made with almost 70 constitutions of 70 countries. Very, very intense arguments went on, and finally the judgment. Though I said the judgment in a very simple manner, the judgment consisted of 703 pages long judgment. This is Keshavananda Bharati versus State of Kerala. And who was the advocate who fought? Who was the person who argued for Keshavananda Bharati? That was Nana Bhai. Have you heard of this person? Palkhiwala, one of the greatest advocates of all time. Okay, Nana Bhai Palkhiwala. Now, just this much to note down. Now let us think about our old Kerala and what led to Keshavananda Bharati's court case. Now, let me go to another slide. So after getting independence, it was seen that though we advocated for equality, etc., the whole of the wealth and all those things were concentrated to certain areas or certain people or certain trust or certain kind of people. So in order to bring in and improve and improve the social and economic conditions of the people of Kerala. Kerala government brought in something known as the Kerala. Very important. These are all very important historical as well as very important reforms, which has really brought in what Kerala in which we are living now, and India in which we are living now, because the state in which, or the conditions under which people were living earlier was not even comparable. They were all having so much, there was poverty in one end, there was richness in the other end. These has been eradicated. All the socio-economic inequality had to be eradicated. So Kerala government brought in something known as Kerala Land Reforms Act of 1963. Kerala Land Reforms Act, very important, of 1963. So what is that? It put restrictions on how much each person or each trust or each of them how much property can each own. So this actually brings in restrictions on the property possession. Okay. That is, if X is a person who has a lot of land property, and Y is a person who doesn't have any property at all, they have to bring in an equality in this. For that, Kerala government passed the Kerala Land Reforms Act. Now, by using this land, this reform, Kerala government acquired the land of Edanir Mud in Kasaragod. Okay, acquired some land of Edanir Mud in Kasaragod. Now, what happened is that when this land was acquired, I hope some of you may remember the Malayalam version of this, which is Micha Bhumi. One person can, however rich he is, however property he has, by this Land Reforms Act of 1963, some of the land will be acquired by government. He can have only this much area of land. The rest will be acquired by government and given to poor people, people who do not possess. So similarly, Kerala government acquired some land from Edanir Mud. Then what happened is the Edanir Mud found it difficult for its function because so much they were depending on some of these lands and the or maybe cultivation. I don't know about those in detail. So because they don't have that much land anymore, they found it difficult for their functioning of the mud. So their head of this mud, called Sri who Keshavananda Bharati, challenged this in court. What was his contention? He said this was represented by none other than Nanabai Phalkiwala. He filed a writ petition. Now we'll discuss about what writ are later. Okay, what do you mean? It is what about that later? He said, what was his contention? He said that this law or this reform violates his fundamental right. Now, listen carefully. Fundamental right is given in the preamble and the constitution. His fundamental right was the right to property. If Kerala Land Reforms Act, as per Kerala Land Reforms Act 1963, the fundamental right is not completely given to a person because there are some restrictions. They put in some restrictions. But then the Keshavananda Bharati he contested that it violates my fundamental right to property. Now, what happened is that two things, very, very important. Article 368, the question was, Article 368 gives power to the Parliament to amend. Okay. Parliament said that we have unlimited powers to amend the Constitution as well as the preamble. But the Supreme Court, what did the Supreme Court say? Supreme Court said, no, you have only, it imposed restrictions. We have seen imposed restrictions as per Ray Berberry case, so there were two questions. One was, you had the Parliament on one part, you had the Supreme Court. Parliament always said, we have unlimited power to amend the Constitution. So fundamental, it's not a violation of the fundamental rights. We can amend as per that and so bring in Land Reforms Act. Supreme Court said, no, you cannot amend all those things because you have we are imposing restrictions. So there was a power struggle there, tussle. So many more cases were discussed and so on and so forth. And finally, Parliament brings in more amendments. Parliament, what they do is, they brings in more amendments to the Constitution by which the other are, and they brought in something known as 9th schedule. You should remember this as well. Certain things which I highlight and which I give more importance, you should remember. So Parliament, what they did was, this Land Reforms Act passed by Kerala government was brought into the 9th schedule. What is the importance of 9th schedule? Something that has been brought to 9th schedule cannot be touched by the court. Court cannot review anything that has been brought into the 9th schedule, which means court cannot review. Now what happened? The Land Reforms Act is now within the 9th schedule and court cannot interfere. Finally, 13 judges were there, many more arguments were there, and finally the final outcome of Keshavananda Bharati case was that we discussed the preamble, final discussion. Preamble is a part of the Constitution, and up to what extent can this be, on what extent that can this be amended? It can be amended. Can be amendable with restrictions. Restrictions means basic structure cannot be violated. However, Parliament cannot interfere with the basic structures. Okay, so now the question is, what is the basic structure? Which is the basic structure? This kind of argument is still going on. Still going on in the sense which the government had the court has listed a number of areas which are the basic structure. As Indian Constitution and court proceedings go on proceeding, more and more cases may come up. Maybe more and more features may be added, so that those are all basic structures that cannot be violated. Now, the question is, why these amendments have to be brought about at all? Why do you require these amendments? Because when the Constitution was adopted and drafted and adopted, the situation in India was not what we see it now. The situation has totally changed. The communication, for example, the way in which we communicate with each other. See, now I am using my computer, Wi-Fi, and communicating with you. There are so many more things that have come in social media and all those things. There may be a case where government finds that so many amendments have to be made, so only by which the rules can be imposed on or only by which anarchy cannot or chaos cannot come in. So all those things, amendments will have to be done to the Constitution and preamble as well for the smooth running of the country. As and when changes, or as and when a need arises because of the change of the circumstances in which we are living, then amendments have to be made. So that is all for today. So let me just put this all into a nutshell. What we discussed today was a little more extension of the preamble. Yesterday we discussed about the preamble. Now today what we discussed is the important court cases. I have tried to make it as simple as possible. The important court cases that were there, that arose with regard to the preamble. The first one was the Berubari case, in which the court said preamble is not a part of the Constitution, and hence by using Article 368, Article 368 gives the Parliament power to amend the Constitution. But Article 368 cannot be used to amend the preamble because preamble is not a part of the Constitution. But later on, came the Keshavananda Bharati case, which is one of the most important cases in the history of the Supreme Court. So it saved the democracy. That is what they say. So in Keshavananda Bharati versus State of Kerala case, the Supreme Court again looked into this matter and came up with the answer, with the judgment that preamble was adopted and enacted in the same manner as the Constitution of India. So we can consider preamble to be the part of Constitution, and hence Parliament has the power to amend the preamble as well by using Article 368. Now, but then a restriction had also was a limitation, or a restriction was also imposed on this judgment by the Supreme Court. They said, yes, you can amend, but you cannot amend it in any manner. make sure that the basic structure of the constitution is not affected at all. So what all things or what all features of the basic structure come under the basic structure of the constitution, those are they are not well defined as of now, because as more and more cases come into the Supreme Court, more and more features are being added which are considered to be the basic structure. This is what we discussed today. In Keshavananda Bharati case, I told you in a nutshell what it was, so that you will also remember. So when you write an exam, and when you, and I hope a majority of you may even try for civil service later on, these small things which I tell may really help you finally. And I'm only happy to do that. Now, as I told you, I'm not an expert in all these things, yet I'm trying to help you in that manner. Okay, so that is all for today's class.